Hi there, folks. It's Christine Scudder here to talk with you about legal and ethical standards of care as social workers here in California, Practice Primer. So the course objectives for this module are to introduce you to key legal concepts affecting social work practice in the state of California, to help prepare you to participate in an engagement skills workshop, which will be a next phase, where you'll practice discussing key concepts with client systems so they're adequately informed of protections and the related limits, to help you identify resources to make practice decisions that conform with legal and ethical standards, which are often confusing and can be in conflict. Activities in this module include listening and watching to lecture material, reading and analyzing material, completing a quiz to demonstrate your comprehension, and to begin supervised practice. So I want to start by talking about a couple of things in the law involving defining our professional relationship. And as I do this, I want to acknowledge that not all social workers become or are even interested in psychotherapy. So why start here? I want to acknowledge that there are a number of ways in which standards of practice for social work as a profession in this state are guided by particular elements of work where social workers may be involved. Okay, so in the California Evidence Code 1010, there are legal definitions for who and what constitutes a psychotherapist and who and what constitutes a patient relationship. I'm not going to go into all of those details here because this isn't a training about being a psychotherapist, but I want to acknowledge that as a place to begin, and I will refer to this concept of professional standards of care and practice within the larger social work profession and how those can really, where they come from, right? So I want to acknowledge that. So I want to start by talking about legal requirements of consent. And these requirements are actually born out of those relationships that I just mentioned on the prior slide, that of psychotherapist and patient. And so even if that is not your relationship as an intern, as a provider, the legal requirements of consent for our profession as a whole are predicated on those legal definitions. So the first is that the client must be competent to consent. And I will talk more about competency, particularly in the segment on elder and dependent abuse and neglect reporting, which is also a part of this module. And so competency also has, both in terms of a person's mental capacities, right? Their competency. And that competency is also, when we think about children, is also predicated on their age. So children under the age of 12 are generally not viewed as, they are not able to consent for practices or services. There is some reading that you need to do for this week that relates to minor consent in California, that some youth 12 years of age and older may consent to some services if they are deemed to be mature enough to understand the context of what they're consenting to. So I do want to be very clear that just being 12 in the state of California does not allow a child that age to legally consent to services. So please do review those materials carefully. But again, this first one has to do with what a person is developmentally able to consent to. So that has an age component, and it has a level of individual assessment related to competency component. Just because a person is over the age of 12 and mature, and or over the age of 18 does not does not automatically mean that a person is competent to consent. Even when a person is not competent to consent, we can always seek their assent. And assent is not a legally binding, but is more of a way of showing respect to the person that you're working with. Even if we're working with a very young child whose parent is saying they have to come see you for a service, you can ask them, like, your mom thinks it's important that we talk about X, Y, and Z, is that okay if we talk about that today? And you can get their assent to engage in activities with you, right? We can still treat people with that respect. The same with maybe a dependent adult who may be conserved and doesn't have a choice but to participate in services with you. You can say, I know that, your conservator thinks that you need to be here today, and here's what they think we should talk about. Would that be okay with you? Right? So people still have some choice, even if they can't legally consent. The consent, for it to be legal, must be voluntary. It's important to know that as social workers, we may encounter people in a host of contexts where their participation is not voluntary, where it is court mandated. We might be running groups or offering particular support services to people who are in court mandated settings. We might work within jail or prison settings. We might be a part of someone's court ordered case plan, right? In terms of maybe getting their children back, they have to engage in a parenting class with us, or a substance abuse treatment program with us, or a therapy session with us, or what have you. And in those situations, the notion of voluntary is a little tricky, right? And so if they must do it, then again, we may be looking at asking for their assent and really recognizing that. As a part of our practice. But as a legal requirement for consent, it must be voluntary to give that consent. And I just want to say too that, even though a service might be court mandated, a person doesn't have to do it, right? They can be in violation of the court order. So, they can voluntarily decide not to comply and not to engage in that service. So if someone is consenting, they are saying, okay, I'm going to do it. I just want to acknowledge that the landscape within which we may be offering that service may feel anything but voluntary. And so I think we need to be really aware of that as well. The information provided to the client must be considered adequate. Adequate is a pretty loaded term that is open to a lot of interpretation. So over time, the law has really looked at how to define it. And again, a lot of these sections are kind of predicated on the psychotherapist-patient relationship, whether or not that is your relationship as a social worker. It is considered a standard of practice that adequate consent addresses, make sure that people understand the nature and the purpose of the treatment or the type of service. Why are we here? What is the end goal of doing this work with you? What are the probable risks and benefits? It's important for us to unpack those with our clients, to talk about what are things that people who have done this program before have gotten from it, and also what could be some of the risks of participating in it. The costs are important to review, even if you might be, and a lot of us are working with financially strapped communities who we may be serving folks in low or no cost settings. We may be billing insurance. And so there's no money changing hands, quote unquote, but that doesn't mean that there's no cost to the service. So we might want to talk about the cost of time, costs in terms of transportation to get there. If we're billing insurance, their insurance, the cost might be, listen, in order for me to bill for this service, I have to give you a mental health diagnosis. Now that's getting into the details of that is a bit outside the confines of this particular lecture, but of course, it's unethical and illegal to give someone a diagnosis that is not accurate, and to ever operate outside your scope of practice if you do not have the training skills and requisite knowledge and state of licensure, or working under someone else who's licensed to give a mental health diagnosis. That's not legal to do anyway. But what I'm saying is that in some settings, that's kind of the cost of getting the service, right? Is that you are open to being assessed for a diagnosis, and that would need to be reported to the insurance company, for example. Okay, so costs can have a variety of meanings, and informed consent requires that we address those. That we talk about the potential effects on other people and life activities. I don't know about you. I've definitely, I'm pretty open about this. I think as a social workers, and I've also been a therapist. I've been on both sides of the couch, as it were, and I, think it's a really powerful way of receiving support. It's not the only way, it's one way. But I will say that in many a therapist's informed consent documents, including mine and ones I've read from therapists of mine, have said, there's this section that talks about how, therapy can be a very helpful place to kind of think through challenges that you might have in your life. And sometimes the changes that you might make are welcomed by people in your life, and other times they may cause frustration or concern, right? Something like that. So the idea is that, sometimes people kind of like you just the way you are. And it might not be working for you, but it might make your sister-in-law really frustrated if you suddenly, set boundaries with her, for example. And so it's kind of letting people know like, hey, it's not all, rainbows and unicorns when we make changes. And so to kind of be able to help people understand what some of those challenges might be. Of course, you can't predict all of them, but it's kind of a general statement about that. And then of course you can unpack it further and make sure the person understands what you mean, and you can talk about that. Also, it's important for us to give reasonable alternatives. I talked in the last module about professional humility. It's important to recognize that we are never the only game in town, even if we work in a very rural community or in a space where we might be one of very few of a particular kind of provider, and we might be really good at it. Respectfully speaking, you're not the only way, I'm not the only way that someone could get the support that they need. There are reasonable alternatives. Someone might work with maybe a different provider, providing a similar service in another location. Maybe there's an alternative to receive it in person or over telehealth, something that's different from how you're offering that service. Maybe the service is related, but it's not the same. For example, someone who may be consenting to a substance abuse treatment program, may be able to receive support through Alcoholics Anonymous or Narcotics Anonymous. And that might be the way a 12-step peer program might be a way that a person achieves and supports their recovery, right? It doesn't have to be in a residential program. It doesn't have to be, with a KDAC provider, for example, right? So there's more than one way for people to get the support that may be helpful to them. Now, we can certainly through our assessment say that what we found is that in general, certain things we have found to be more helpful if, X, Y, or Z situation is more acute or more causing more problems, or, the reality of this is that because this is a court mandated program, you could definitely, work with another provider, but I need to let you know it has to be a court approved program, right? So we don't want to just throw out a whole bunch of alternatives and set people up to be out of compliance if they're there, for compliance reasons predominantly. We do want to make sure that those reasonable alternatives take their context into account. Okay. So I want to talk a little bit about values. Our values are important to think about. They're really look at our beliefs, our attitudes, and preferred conceptions about what's good or desirable that can really provide a direction. These are really internal for us. We may have our own personal values from our cultural upbringing, from our family, from our class, from our, when we think about our own intersectional identity, different parts of our identity, there are inherent values and collective agreements in the various communities of which we may be a part and of which we may be living and come up in our lives that inform our personal values. And then we have the profession values, the professional values as particularly noted by our national body, the National Association of Social Workers, through the Code of Ethics. Each of our ethics underneath those are values. Key ones being service, social justice, dignity and worth of the person, importance of human relationships, integrity, and competence. So these are all really important values that undergird the work that we are doing and really should be informing them. Then we need to think about ethics. There's standards of conduct, which are standards of conduct that an individual uses to make decisions, right? There's our values that might guide how we arrive at a situation. And then our ethics are often the things that help us fine tune our thinking and then kind of help us figure out what decisions we might make. Ethical dilemmas, you will see and encounter millions of them probably as a social worker, no matter how many letters you get after your name, no matter how many years you've been in the work, because we are working with the human condition that is so variant, and there's the interplay between the person and their environment and the practice environment for the people we're working with, and so too for ourselves, and that we're constantly changing and evolving. With respect, the role of professional humility is something that you need, not just when you're a student, but throughout your career as a social worker. And because this work is rarely black and white, while the law might suggest that it is, right, something is either right or wrong, it's legal or illegal, the work that we do is often very much, social work is very much in the gray, kind of this kind of faded gray that you see on these slides, if you're visually taking in the slides. And so, to kind of think about how we make choices between two mutually exclusive courses of action, we sometimes may be choosing between two positives, which we don't always think of as an ethical dilemma. Sometimes I think of those as like awesome situations, but they can pose dilemmas, right? Or the avoidance of two harms. And we will frequently find ourselves with different values kind of being pitted against each other in different situations. Like, for example, our value of our values related to social justice and dignity and self-worth of the person, where we might, for example, want to always support people to make their own decisions, whatever those might be. We are inherently facing an ethical dilemma when these are at odds with our professional integrity, perhaps that is dictated through laws and our assessment as social workers that a person may be making choices that place them at risk. Maybe they are an adult or dependent adult who lacks capacity to understand those differences. And so while I might believe in a person's, dignity and self-worth where they can make their own decisions, and from a social justice standpoint that, people should not have to be subject to the arms of the state, if you will, or government entities like protective service agencies, that may come and bump up against, what it means for in my profession to act with integrity and competence as defined in the law, for example, right? Those are one of many, right, ethical dilemmas that we might face. And so you'll get a lot of chances to practice with this, both in class and in your internships. And I strongly encourage you to think about how you know something is an ethical dilemma, which we'll get into in a minute, and then what you do with it, which is very important. So there's 5 fundamental steps in addressing an ethical dilemma. And these are pretty basic, but I just want to start by saying the first is to name the dilemma. And you might be like, well, thanks, Christine. I'm in graduate school at UC Berkeley, and that's pretty obvious. Like, yep, I need to know the dilemma. And that might sound really obvious. And when we're in a dilemma, it is often a time that is fraught with confusion. We might be dealing with a crisis with someone. We might be in a situation where we are feeling anxious personally or professionally because we find that we may, that we are being forced to make a choice between two or more ways of being and showing up in the world and in the work that may be at odds with one another. And we may feel like we're in an impossible situation. This can sometimes lead us to make impulsive decisions and or take impulsive action. So it is important to the best of our ability, unless we're dealing with an immediate safety issue where we need to grab someone out of running into traffic or something, or an imminent risk of harm, that we can really step back for a moment and name the dilemma. Take a minute, even if it's literally writing it down on a piece of paper, slowing yourself down to say, what is the dilemma here? Okay. Is the dilemma that it's really not an ethical dilemma, it's just I'm overwhelmed and I have no idea what to do? Or is this actually an ethical dilemma where there are multiple steps that I could take that have mutually exclusive outcomes, and to name what those are? Then you want to sort the issues, right? What goes where? Maybe part of my dilemma is that I personally don't agree with the law. I personally object to doing what I have to do in this moment, professionally speaking. That might be a set of issues. Another set of issues are the legal mandates. Another set of issues might be my fears about what might happen. Another set of issues might be what the client has said would happen if I take certain actions, is to really be clear what my supervisor has said, right? Number 3 is solve the problem. I have to this is kind of a weird analogy, but one time my wife was trying to teach me how to play racquetball. It was really not pretty. It was at the YMCA in downtown Oakland. And I was like, okay, I'm going to really try this. I was like, let me see if I can do it. I'm not the most sporty person. And she's super sporty. So she's like, okay, here we go. So we have the racket, we have the ball. She whacks it against the wall and it's coming at me like 9 million miles an hour. And she's like, hit it. And I'm like, that's it. Like, that's my training. So I feel like number 3 is kind of like that, like just solve it, just hit it, figure it out. I don't mean hit people, of course. I don't mean that. I was referring to my racquetball analogy. In any event, we need to solve the problem. We can't just respectfully, we can't just sit and kind of ponder. We do have to get into action, right? So while taking a breath, taking a moment, trying to name and sort the issues is important, it's also important that we do take action and solve the problem. And in the end, we do need to make some kind of a choice. And that's part of what being a professional social worker means, is that, we take responsibility for our actions and we go ahead and we make a call and we do it. Now, that doesn't mean you're doing it by yourself. We'll talk more about consultation and the critical nature of that. And so sometimes part of solving the problem, and my hope is that most, if not all times, part of solving the problem is that, especially when dealing with an ethical dilemma, that you're working with someone else, whether it's a supervisor or someone else who has content expertise to help you to respond in a professional manner. Then you want to look back and evaluate the outcome, right? By its nature, an ethical dilemma means there are multiple ways you could have responded. So you want to look back and say, well, given what happened, would I do it this way again? And why? And then to kind of think about, are there ways we could do this differently, right? Are there ways that would have made it more effective? And that's part of the reflection piece. But another part of reflection is also about to really get honest with yourself. This work is not just something that you phone in, right? And kind of zone out and just do some steps. Our use of self is very much all up in social work. No matter if we're doing micro, meso, or macro practice, we want to look back and say, like what was running me there? Did I lead with my value around client dignity and self-worth? Did I lead more with being risk averse and doing what I thought my supervisor wanted? Did I override my judgment about what the client needed and focus too much on what my supervisor wanted? Were my emotions running me? Right? We're often dealing with complex issues. Many of us come into this profession having personal experience with some of the issues that we are here to support other people to redress. And so it's not unusual for us to have our own personal feelings and reactions. And sometimes those can take over a bit. And we might not always realize that in the moment. Even when we do try to step back and name the dilemma, sometimes it's only upon reflection that we realize quite how much of our stuff was in the soup, if you will. And so it's important to reflect upon that. And that reflection, good reflection, thoughtful reflection, has a self-reflection component as well as a reflective component in supervision. Again, ethical dilemmas are not things that you want to handle all by yourself. That doesn't make you more competent. Respectfully, it can make you much more reckless if you insist on handling these things by yourself. It can get you into trouble legally and ethically. But more importantly, well, maybe not more importantly, but equally importantly, we want to think about also the impact on our clients when we fail to be able to have the humility to step back and realize that we always benefit from multiple points of view and reflection. So Elaine Congress tackles this, I think, in a more nuanced way, better than, quote, solve the problem. The other list is kind of a basic one, but I also really appreciate this model that she shares. And so ETHIC is an acronym for examine. So look at relevant personal, societal, agency, and professional values that are at play in the dilemma. T is for think about the ethical standards of the NASW Code of Ethics that applies to the situation. Part of why we ask you to think about the NASW Code is because that is considered a standard of our profession. And so if you are ever making choices in ethical dilemmas or otherwise that land far outside of our professional code, people will really not just raise an eyebrow, but really ask you, well, what are you basing this on? And you need to be able to stand behind that. So just to understand that the Code of Ethics is not just a document that you read in graduate school, but rather is very much used as a litmus test upon which to compare our actions and our ways of showing up in social work practice. So how does the code apply to the situation? And then, of course, we need to look at relevant laws and case decisions, right? Because ethics are one thing and laws are requirements, right? The H stands for hypothesize. So think about possible consequences of different decisions, right? You might think about a pro and con list. Who would be harmed if I do this? Who would be harmed if I don't do this? And to kind of think that through. the silent I in ethic, and then the C is consult. And I put that in all caps. If I could make you all a t-shirt or a tattoo that you'd have for the rest of your career, it's consult, consult, consult. Again, no matter how many letters you have after your name, as a licensed clinical social worker, I still have consultation groups that I use for when I'm supervising people. I have content experts that I go to when I'm wrestling with particular dilemmas and certain topics or certain populations, right? That it might be more outside my typical scope of practice, to be able to, to show up ethically, mindfully, and respectfully, and legally, right? So that's very important. So I encourage you to hold on to this acronym. Maybe you could write it down, or you could, put it in a place that you would refer to, because I promise you that you will experience many an ethical dilemma in your practice. Some of your reading for this week includes this article on what is an ethical dilemma. And just briefly, what I want to say is, to really recognize this left-hand side addresses things that are kind of live more in the professional realm of our professional code of ethics and laws and policies. And then the things that kind of are more at play in our personal lives, but are nonetheless very much a part of our work, right? Because in social work, we are the tool of our profession, right? We are our primary tool. And so what happens personally matters a great deal. So our own values and our morals, as I've talked about in a prior lecture, just because we often talk about leave your biases at the door, leave your values at the door, we can say that. But again, there is no magic thing when you cross that threshold that those things escape your knowledge and that they get reinserted back into your heart and soul and mind when you go home or something, right? And so, these things are always at play, and we're constantly making choices and decisions about what are we leading with, and being clear about what you're leading with and why, and consulting about that can be very helpful. So I want to talk about some other terms, laws and ethics, and other terms that get kind of conflated. So I want to talk a little bit about the difference between privacy and confidentiality. Privacy is a person's constitutional right to decide how much personal information can be shared with others. This is noted as a protection under the Fourth Amendment of the United States Constitution. Whether a person's privacy is actually protected has to do with people's behavior in the world, and also how courts and others may view a person's rights. Just because a person has rights does not mean those rights are always respected, and that's very important for us to be mindful about. When we think about confidentiality, this is an obligation that we have as professionals, right? Privacy is a person's right to privacy. Confidentiality is like an individual person. Confidentiality is a professional obligation not to disclose information about a client, research subject, supervisee, employee, etc., obtained during the course of a professional relationship without that person's permission. Okay. Now, a significant section of this module has to do with exceptions to confidentiality. Okay. These are the baseline expectations of confidentiality, and there are some important exceptions to that in our role as social workers, whether we are therapists, whether we are case managers, whether we are engaged in macro level practice, we still have these obligations. So I want to talk about HIPAA, the Health Insurance Portability and Accountability Act of 1996. Just as a side note, HIPAA has two A's, not two P's. Two P's is HIPPO, not HIPAA. So think HIPAA. Please spell it correctly. Definitely people do notice that a lot on student resumes and professional resumes when people might say, follow HIPAA guidelines. Make sure you use the acronym appropriately. So what is HIPAA about? It protects the privacy of patient health information. It's a federal law that applies to health and mental health care providers who transmit health information in an electronic form. This transmission includes electronic billing, using a billing service that transmits information electronically, including over the internet, in connection with certain administrative and financial transactions that are known as covered transactions. Okay, so there is a very formulaic definition of HIPAA, and this is part of it. And I want you to understand that, it is born out of patient health and mental health settings. The notion of PHI It refers to individually identifiable information in any form. This can include oral communication as well as written or electronically transmitted information. So the notions of HIPAA and PHI are things that often get talked about and have important roles to play in terms of our social work profession standards of practice. So protected health information, or PHI, again refers to information that's identifiable to a specific individual, maintained or transmitted by a covered entity in any form. This is the legal definition under HIPAA, right? This could be oral, paper, or electronic. So we have a responsibility as professionals to protect our oral communications in terms of things like leaving voicemails, talking to people on the phone if we're not sure who they are, conversations in the hallway, conversations in the workplace, paper, like paper charts. A lot of our charting has gone to electronic health records, but many places also keep a paper file of maybe key documents like consent forms and otherwise. I think we're still a few years before we're entirely electronic. If we ever fully get there in our profession, mental health is particularly slow in this arena. A chart, a bill for service, hallway conversation between clinicians, et cetera. These all are situations that could include PHI, or protected health information. Okay, so we need to be mindful about them in all types of settings. This includes, but is not limited to, demographic information, such as name, address, and age. To be clear, you could be referring to someone by their initials only, and then talking about a very detailed situation in the hallway with one of your providers or coworkers. Even if you're not using the person's name, their demographic information could be implied or inferred. People can infer who you're talking about, particularly when we might be working in settings where groups are quite small, maybe more of an insular group, or a very highly specialized community is served by the space that we're working in. Everybody knows everybody kind of thing. So just because you don't say someone's name doesn't mean that you might be potentially violating protections for health information. So we need to be very aware of those kinds of things. And so thinking about some of the standards and rules related to HIPAA. The HIPAA has what's called the privacy rule, which means sharing only the minimum amount of information necessary in a disclosure to accomplish the intended purpose. Okay, so clients will sign, particularly in our more formal settings, not just therapy settings, often case management settings and any type of service settings, to be able to talk to someone else who's not covered under our umbrella of confidentiality. We need a release of information, and a respectfully and thoughtfully legally executed release of information. We'll talk about to whom we can share the information, what type of information is to be shared, and the expiration of that. And it needs to be executed by someone who can legally consent for that disclosure. Okay. And so just because, for example, let's say as a therapist, your client signed a release of information allowing you to confirm your attendance to CPS, Child Protective Services, who has sent that person to you for treatment in order to comply with their case plan. Just because you have that release of information does not mean that you share beyond the minimum necessary. If the confines of that release of information are to share about attendance, then you share the dates that they attended. You do not go beyond that. You do not talk about the context. Well, they're always late because of childcare and this, and that. If it's, if you're asked about attendance, what are the dates they showed up? Were they ever late? That can fall under attendance. You can do that. But in terms of sharing more than that, you need to look at what's the intended purpose for the disclosure. You can talk with your clients about, hey, the worker asked these other questions. I think if I were to give them context, that would be helpful for your case or helpful for you. But you want to talk to the client about that. You don't want to go into the whole backstory or a lot of extraneous information. The minimum amount necessary is the requirement. There's also a security rule which defines confidentiality to mean that electronic PHI is not available or disclosed to unauthorized persons. Okay, so it's important that even not only you withhold disclosure intentionally, but also you take safeguards to ensure that it is not unintentionally disclosed to unauthorized persons. So this includes having administrative safeguards. An example of this, when I was a child protective services social worker, as a part of our standard assessments, we might run a criminal background check on a parent or a caregiver or a potential foster parent, for example, to help us look at a safety assessment, or to look and see if this person was qualified to be, maybe a foster parent or what have you. And just because I, as a social worker, am allowed to run that check, and we have administrative assistants in our office who are directly involved in and responsible for maintaining the charts and making sure that they're up to date. And, they may even be helping to type reports that include some information about clients and things like that. Even under those conditions, we would put the results of the criminal background check, the CLETS, we would put it in an envelope that was marked confidential. We would seal that envelope and put it in the chart. This was an administrative safeguard so that people just kind of flipping through the chart or making sure to file X, Y, or Z form didn't inadvertently see things that they didn't need to see. Okay, that's an example, right? It's a safeguard to protect things and really, again, thinking about the minimum necessary. Physical safeguards, of course, having locks in place, whether those are electronic or physical locks, which we'll talk about. Technical safeguards, which are again more those electronic, password protection, two-step authentication, using HIPAA compliant services for the type of work that we're doing. For example, a regular Gmail account does not have the same technical safeguards as an email service like Hushmail, which is HIPAA compliant levels of protection. And they are willing to sign an agreement that they will uphold HIPAA guidelines in maintaining information in that system, for example. So I want you to understand, I'm going over all of this because whether or not you are working again in health or mental health as a social worker, HIPAA is absolutely viewed in social work as a standard of care. Okay, so if we operate outside of that, even though we might not be what's considered a covered entity and we're not billing and using electronic services to do that, which are kind of some of the technical definitions of who is required to follow HIPAA. HIPAA has emerged as a standard of care for all social workers, and that is absolutely true here in California. We need to uphold our professional code of ethics and regulatory standards for client privacy and confidentiality, and increasingly, our standards make reference to taking what are called responsible steps to protect security of PHI, or protected health information. So a standard of care in social work for records is that they are kept behind 2 locked doors. If you have old school paper files, those files should be in a locked cabinet behind a locked door, okay? There should be digital security, as I talked about, passwords, firewalls, protection, plans for if there's a data breach is considered a standard of care. Fax machines, some of you might not know what those are. They are more frequently and continually used in hospital settings, and in schools still have them, and some other offices do. If you're using a fax machine and you're sending information via fax, the standard of care is to call ahead, verify the number is correct with a human who is appropriate to receive the information, and ask and ensure that a recipient is waiting to receive it. In one of my roles over the years, I was a field consultant over at, well, it doesn't matter. Anyway, I was at San Francisco State. I went out and visited a student who was placed at an unnamed public high school for their internship. And I was standing in the waiting area for the health center for someone to greet me and give me access to the back where I could meet with my student intern and their supervisor. And they were dealing with something, so I was waiting. And I heard the fax machine beep and go off. And in the process, a very long, I could hear a lengthy fax was coming out, and the papers were shooting all over the floor. I don't know if you've ever seen this, and so one shot out underneath the door and like literally at my feet. And I stood there and there was no one around, and I had asked for assistance. I rang the bell, nobody came. And so I'm standing there, and I'm realizing that this is I glanced down at the floor, and just given my work experience, and one of my roles over the years was to be a hospital discharge planner. And I recognized the logo, and, I could see it. Just really a quick glance let me know that this was a hospital discharge plan from a psychiatric facility, it appeared. And I was like, oh my gosh, and this is shooting out all over the floor. It's all over the floor in the reception area. That was I couldn't access it because it was locked, but some of it came out from under the door into a public space, where other students could be. And there was actually someone behind me waiting. So I discreetly picked up the paper and turned it upside down, and reached over and put it on the desk. And then when someone came to greet me, I let them know what happened. That was a situation where they didn't call ahead to find out if someone was waiting, right, to receive that fax. And potentially we could have had protected health information out in the waiting room where students could have picked that up, or teachers, or someone else. And I had no business knowing about that. And I made an ethical decision that it made sense for me to pick it up, because I knew it was none of our business, to turn it over and not look at it, and to secure it as best I could, and to give it, to turn it over to someone who could handle that. Right. So I made a decision in that moment about how to handle that. That's an example. So a long example, sorry. And so, if you are working with clients and you need to follow up about appointments and that, it's important to talk ahead of time. And this is often a part of our consent to treatment, is how do we handle, communication? Do I have permission to leave you a voicemail, right? Sometimes people are sharing their cell phones with 5, 6, 7 people, or even just one other person, and their voicemail is not private, or they're borrowing someone else's phone. So for me to say, hi, this is Christine Scudder calling with Alameda County Behavioral Health Services. I'm just calling to remind you about your appointment, right? And your boyfriend or whoever picks that message. Now I've just disclosed that you may have a mental health condition, right? I have inadvertently expressed PHI. So, you want to have some agreements. Maybe you agree that you just say, hey, it's Christine. Just remember we're meeting Monday at 1, right? And not say where I'm calling from. Whereas in some settings that may be viewed as unprofessional, right? So you want to kind of have some conversations with your clients about things like that. Also, similarly, things like texting, right? Even if a person has, agency over their phone, right? And they maybe aren't sharing their phone. If their phone is turned up in a restaurant, or, when they're out with friends or something, or, a family member, and the text comes through like, don't forget your therapy appointment on Thursday at 3, just to be mindful that someone could see that. So to really talk with your clients ahead of time about email, about texting, could someone intercept it? If someone may be experiencing relationship violence, their partner may be monitoring their texts, their calls, who's calling you, what are they calling about? And sometimes even the secrecy of it could cause that person to think, oh, are you cheating on me? Are you jealous? Right. So to really kind of assess some of those things that may seem very basic, are considered part of our standard of care as social workers. So I want to talk about confidentiality breaches. There are times when we must breach confidentiality, and there are times when we may do it. So in the law, when something is a must, typically the law will say shall. And in the law, when we can do it, it means we won't get in trouble if we do it, and we won't get in trouble if we don't do it, is a may. Okay. So under the exceptions to confidentiality are when clients communicate serious threat of physical harm against a reasonably identifiable victim or victims. This is a time that we must breach confidentiality. I will talk about that a little bit further in a moment. Another time is when we know or reasonably suspect child abuse or neglect. Another time is when we have observed or have knowledge of an incident that reasonably appears to be abuse or neglect of an elder or dependent adult. And I have separate content that I'm sharing with you in this module about both of those too. And of course, when the client requests or a court compels you through a subpoena. As a side note, if you do receive a subpoena, before you respond to anything, it is critical that you reach out to a supervisor. Your practice setting may also have legal counsel available to you, but do not respond to things until you seek guidance from a supervisor and or a legal professional. We want to ensure that any subpoenas are legally executed, that you understand the terms of what is and is not covered, so that you're careful with that. If a client requests you to breach confidentiality, best practice is to receive a written, signed consent to share information. And your practice settings should have those practices in place. And if they're not proactively explained to you, please ask your supervisor about that, your field instructor. Times we may breach confidentiality are cases of elder abuse that are not mandated. You'll learn more about that in the module on elder and dependent adult abuse and neglect. These are a limited range of cases. So I want to be really clear that by and large, you are mandated reporters for elder abuse and neglect. When you have suspicions of emotional abuse to a child, you must report known or observed emotional abuse. For example, if a child tells you about emotional abuse, that is reported to you, that is seen to be as known. If you personally observed it, you watched it happen, or you were present when it occurred, you must report it. But if you suspect emotional abuse, only emotional abuse, it's a may, not must report. Standard of practice, to be quite honest, is that you report any suspicions of any type of abuse or neglect, but this is a technicality of the law that I want to let you know about. If a client is a danger to themselves or to the property of another, and the disclosure is necessary to prevent threat and danger, this is a may breach, not a must. I will tell you that when clients report or we suspect harm to self, that someone may kill themselves, that it is absolutely a standard of practice that we disclose that to an appropriate party. And I'll talk more about that in a moment. But to be clear, there's what the law says, which is this is a may report. Whereas if we must report if a client communicates serious threat of physical violence against a reasonably identifiable victim or victims. So that's threats of severe injury or homicide. This relates more to suicide. And then of course, the damage to property of another person. You can breach that, but you don't have to. The property damage is one that what I'm going to say about that is that you should consult a supervisor and talk more about that. That line is not always as bright, but it is a very bright line in terms of our professional standards of practice to take further action if we believe that a client is a danger to themselves. Then there may be certain other situations that involve exceptions to privilege where you may breach that will really be outside the purview of this presentation and more of a legal, a longer legal presentation that you may receive at different points later in your journey. So at the time of the confidentiality breach, remember we talked about this under HIPAA, we're sharing the minimum necessary. So what does that mean? Nuts and bolts. Release only what is listed on the properly signed and executed release of information, right? So this is in cases where the client is giving you permission to do it. They've asked you to talk to their substance abuse counselor about how they're doing in your case management program or what have you. You only release the information that is needed to protect the client or others or the property of others. This is in those mandated reporting safety type of situations. So in these situations, the client is not signing a release of information. You may need to contact law enforcement or mobile crisis or another party to ensure the safety of a client and or other people who may be at threat of harm. So you only share what's needed to protect the client or others. So history, for example, or a tremendous amount of context is not appropriate for you to be sharing with law enforcement. What is important to share is what is the immediate issue? Why do you need to make this disclosure right now? And then after that, you want to follow up clinically based on the needs of the client. And I say clinically, even if you're not as a therapist, it's really attending to the needs of the client. Sometimes clients will be really upset with us if we need to make a mandated child abuse report, right? And that might be needed to protect other people, right? And the client may be really upset because they can tell that we were the one who made that mandated report. As you'll hear about in that lecture, your identity as a mandated reporter is kept confidential, but sometimes the context of the report or the timing of it, clients will know, well, you're the only one who knew about blah, blah, blah. So even if you don't tell me, I know you're the one who made the report, right? And so there can be this feeling of betrayal, why did you tell on me? Why did you cause these systems to come into my life? I feel violated, those kinds of things. We need to be able to come back and attend to that, right? We need to be accountable to the choices that we make. In some situations, you may tell clients that you were the one who made the report. In a lot of cases, I would make those kinds of reports with the client present so that they knew, right? But in some situations, it's not safe to do that. I might be concerned they would retaliate against their child or dependent adult, or they were in too much crisis. They were threatening to kill themselves, and that's not the time for us to jointly make a phone call. It might be that I have a colleague sit with them so I know that they're safe while I reach out and get some help. But then afterwards, right, to really debrief what happened, really welcome the client to share with you. They might be mad at you, they might be frustrated, it might have been scary. Sometimes people appreciate it, even if it was hard, and to be ready for those things. And to, of course, be involved in consultation with the supervisor so that you get support. But your office information form, and again, your consent to treatment, which again was really kind of born out of the psychotherapist-patient relationship context, we also use in many, is really viewed as a standard of care for us professionally, is that we need to let our clients know, as a part of informed consent, what are the limits of confidentiality. So people know going in, whether they remember that or whether they really hear you is, is one thing. But it is very important that we tell our clients and that we check for understanding, right? That we not just hand them, and some of you, particularly working in county settings, may have really lengthy release of information forms that sometimes are 10 or 15 pages, and just handing that to a client and acknowledging in your notes, gave client consent packet, that does not mean the same thing as really making sure that someone understands it, right? And remember that, the standards of care for legal consent is that people understand what they're agreeing to. And part of what they're agreeing to is understanding that in your professional context, that there are these limits of confidentiality and that you will be following them. Okay, so it should not be a total surprise. I think it's very disrespectful to clients to have this spring up on them. It is hard to broach that, with people, especially when you're trying to develop trust and you're just starting to meet them, and you might be worried about stigma attached and just really wanting to support people to feel as comfortable as possible. It can be really awkward, right? To right out the gate be like, okay, I really care about you, and here are these times where even if you don't want me to, I'm going to have to share information with other people. This is part of why in the engagement module, the next module, you'll get some opportunities to practice how you're going to deliver the exceptions of confidentiality, because it's something that you'll need to say many, many times. And finding your own way of describing those limits, both how you protect confidentiality and when you may need to override client confidentiality in the name of safety. Finding ways that you feel more comfortable sharing it will help to, can sometimes help clients to feel more comfortable talking to you about it. And are really important for you to be at once clear, right? So you don't want it to be so comfortable for you that you're kind of minimizing what you're saying. And this is a tricky line. And you also don't, want to say things in ways that maybe clients don't understand, or overly legalese that are, not accessible or can be really scary. You also want to make sure that you can tolerate being asked questions about it, because, this is part of what it means to be informed. Okay, so you'll get some chances to practice that with us in your field seminars, and also, of course, in your agencies. And I encourage you to, as you're shadowing people, there might be different things that your field instructor asks you to shadow. And sometimes they may or may not tell you what to look for, and you're just kind of watching. Really want to encourage you to listen and observe how people talk about the limits to confidentiality. You'll see a lot of different styles. I encourage you to kind of pick up things that you think can work for you, and to go over those in supervision. Okay. So I want to briefly talk about Tarasov. The Tarasov case in 1974. This is a case that informs professional practice in social work that actually resulted from a case here at UC Berkeley. There was a graduate student who came here and met a young woman named Tatiana Tarasov, and they saw each other for a few weeks and were kind of dating. And, you know, he kind of believed it was more serious than maybe she did. And then you know, he experienced rejection from her, and you know, had a very hard time dealing with that. And then she left and went on vacation to another country. And he this student told the psychologist that he was meeting with, he was very depressed and upset. He said to his psychologist that when she came back from her vacation, that he was going to kill her. And the psychologist believed him and notified campus police and told them that they felt like he should be committed to a hospital. He was briefly detained, but then released because he seemed to be, you know, rational and wasn't meeting criteria to remain in the hospital. And when she returned from her vacation, he killed her. And so this became a lawsuit against the psychologist and the campus police and their employer, the University of California, for failure to warn them, their daughter, or anyone who could have reasonably been expected to notify her of the danger that she was under. And so that is resulted in the case Tarasov v. Regents of UC in 1974. And the results of that case decision, something like this is called case law, right, is what informs one of our standards of practice and one of our limits of confidentiality. So in cases that involve a serious threat of physical violence against a reasonably identifiable victim or victims, and in those situations, as social workers and mental health providers, we have a responsibility to take reasonable efforts to communicate the threat to the victim and the law enforcement agency. Okay, so at the time of this particular case, the psychologist did report it to campus police, but they didn't report it to the woman who was being threatened and or her family, right, to make those reasonable efforts. And so this is a dual duty, right? It's called a duty to warn. And so when we are under these situations, again, we need to share the minimum amount of information necessary. These terms are mental health related terms, though they are considered a standard of practice, whether you are in the role of a therapist or not. So to be very clear, if you are a social worker, this applies to you. Okay, so the name of the therapist or provider, you give the name of the client who made the threat, the name of the threatened victim, and the content of the threat. Now, sometimes you don't know the name of the threatened victim, and it's important to understand that this is a reasonably identifiable victim or victims. If people make a serious threat of physical violence in general to people who suck, or, you know, a very large category, that, you know, is something you should consult a supervisor about, but as stated, does not appear to fall under these terms, because we can't really identify who they're talking about. We might say, well, what do you mean people who suck? Like who? Well, all the people that work for IBM on the third floor in the Cupertino office. Okay, that's a different story, right? Then you have something reasonably identifiable victim or victims. And then we need to share the content of the threat. What is it that they said that they were going to do? So again, this is a dual mandate, law enforcement and the victim. If you don't know who the victim's name, but by inference, you know, it's the girlfriend or the person that they're living with who might be their emergency contact. You know, again, you want to consult a supervisor if you're not sure, if you feel that the victim is reasonably identifiable. I'm giving you kind of some general examples. Often I get this question of who do you call first? And it's a tricky one. In general, I think it's helpful to grab your phone and go into a space with a supervisor, quickly tell them what happened while you're calling one and have them call the other, so that you're doing it at the same time. If you are in, you know, some of it might have to do with what you know about the victim. They're in the lobby, right, of the place where this just happened, then you may run out to the lobby and intercede there, and then grab your phone and call the police as you can, but you want to catch the victim so they don't leave with this other person, right? So some of this has to do with, you know, kind of the conditions that are unfolding in the moment. As with many things, I highly encourage you to talk about these things with your supervisor in advance. You don't have a lot of time sometimes to consult or think about best practice in the moment. Sometimes sometimes you need to move very quickly. Most of my work and experience is in crisis settings. And so I will just acknowledge that I come from that space. And because of that, I know that for many professionals, crises happen at kind of sometimes the worst possible time. Maybe it's the end of the day. There's very few people in the clinic or the space with you. As a student, by the way, as an intern, you should never be alone. In your place of practice. And if you are doing remote work because of the pandemic, you should always have immediate access to a supervisor. But that said, sometimes you may be in situations where everyone's in a session and everyone's doors are closed and you don't know who to go to or how to figure it out. It's much better to talk about these things before they happen. That way, at least you have a general sense of how you might handle it. Okay. So again, it's a dual responsibility for us to share anything else. It's not unusual for the threatened victim to say, well, how long have they been seeing you? Or what did they, what are you talking about? Or why are they working with you? You can't get into all of that. You can only share the name of the client, the name, to the threatened victim, to say you were named or you were implied, and the content of the threat. This is what they said they were going to do. And I'm calling the police, so to be clear about that. To share anything else is beyond the mandate and could get you into trouble for oversharing in terms of confidentiality. This is defined and codified. This case law decision is codified in Civil Code 43.92, where when you do this, you are acting under the support of the law. So when you hear people say, "Oh, is this a tariff-off?" What they're referring to is this a serious, if this is a time where you would need to report and duty to warn. Okay, sometimes people also talk about it as the duty to warn. So there was a court decision in 2004, Ewing v. Goldstein, where the question was brought up of, does this apply when, there's a threat of suicide and whether or not, that comes from a family member. So whether the client made the threat to the provider, but instead they made the threat to, let's say, their parent or sister or something, and then they call you as a provider. Are you still covered if you violate confidentiality by implementing tariff-off? This is a sticky one, and it's important for you to talk with a supervisor about how to handle that if you do receive a word from a family member about that. The Bella v. Greenson decision in 1978 does, however, make it clear that it does, tariff-off in and of itself does not apply when a client threatens suicide. However, there is an established legal duty to take responsible steps to prevent a threatened suicide. Such steps may, but do not necessarily, include a breach of confidentiality. Sometimes we can do this without a breach of confidentiality because, let's say, we have a release of information to talk to the person with whom your client lives, and we can work with that person and your client to develop a safety plan and a monitoring plan so that they're not alone, and hopefully that they can get immediate support if needed, and then make sure that they have resources. That might be an example where you can do this without broaching confidentiality. But you may not have that luxury, and you may need to involve parties who are able to assess whether or not a client needs psychiatric hospitalization in order to stay safe. Sometimes people will voluntarily sign themselves into a hospital for monitoring. People always have that option. Whether or not the hospital has beds is another matter. And so it is important that you not just merely think of a referral as, quote, doing enough. If you feel that this person should not be alone and is at imminent risk, putting them on a bus to get to the hospital and hoping that they get admitted on a voluntary admission, is definitely taking a lot of risky steps there. Do not make those decisions by yourself, but maybe accompanying that person to the hospital and making sure they get signed in could be absolutely very appropriate to do. And if the hospital were to say, we don't think we can admit you, then you would be there to be able to help make some follow-up decisions, as an example. That may or may not be appropriate for your role. And certainly as an intern, you should not be alone with someone who's imminently suicidal. I share that as a general comment about, there are different ways that we might achieve, the goal of not abandoning clients when they are threatening suicide. So this gets into some other things about kind of whose role it is to address threats of harm to self. When people are not voluntarily admitted to a hospital, there is an involuntary confinement law in the state of California. It's written into the Welfare and Institution Code 5150. So sometimes you might hear people say, oh, so-and-so is on a 5150. That refers to a 5150 hold, and that is defined in the law. People who can be placed legally on involuntary confinement are those who present as a danger to self, a danger to others, or people who are gravely disabled as a result of a mental disorder. Grave disability refers to because of a mental disorder, a person is not able to avail themselves of resources that are available to them for their livelihood. For example, maybe someone who has access to food, but refuses to eat or drink because they think it's being poisoned or that someone is trying to control them, for example, and then they're becoming very ill because of that, and they're not safe. Is one example. And you can talk with supervisors more about that. But again, this has to be as a result of a mental disorder. So again, danger to self is part of that, right? So even though the courts found that that was not the same as a Tarasoff concern, this is absolutely a time when people can be under involuntary confinement. And it is a standard of practice if we believe that a client is a danger to themselves, that we take steps to ensure their safety up to and including overriding confidentiality. It is one of those exceptions. Okay, so it's important to know that on a 5150 hold, a person may be hospitalized for up to 72 hours. Those holds, so that's 3 days, those holds can be extended. And there's different legal statutes that refer to those extensions. Those are decisions that happen in the hospital. Initiation of an involuntary confinement or a 5150 hold in the state of California, a person has to be legally authorized to do that. So just because you're a social worker or even a licensed clinical social worker, you are not automatically authorized to do that. Every county has different authorized personnel, typically through their crisis services at the county level. I have done this work as an authorized personnel for children and youth in San Francisco and with young adults in Alameda County at different points, being part of mobile crisis response teams where we would go out and assess if people were a danger to themselves or others or gravely disabled. If we were able to create a safety plan and keep them out of the hospital, we would do that as a part of our intervention. If we were not, we would arrange for hospitalization. So there are designated mental health folks who can do that work. And then across the state, the other party who can always issue a 5150 is law enforcement. And one of the things I have up here is just a reminder to think about programs like APTP and really looking at, abolition spaces and thinking about how can we get the police out of responding to situations that are more mental health related, both for community safety and also just recognizing what people need in a mental health crisis is really, often more a mental health response. Some communities are talking about ensuring that this change from the hands of the police to the fire department, at least as one way to have another set of supports in place to help protect people who may be physically violent in that moment or actively trying to hurt themselves. Professionals who have that medical training on site, as is the case with EMTs that come out with the fire department, for example, can be helpful. So some places are looking at that. And in places like Sacramento and Oakland, have Mental Health First, which is a community first response, where they go and try to respond both on the phone and in person. They're available only on Friday and Saturday nights at present, but to try to do that first and handle it first without the police. The programs that I was a part of where I was legally authorized to write a 5150 hold, in those cases, I worked for places where we went out without the police. Sometimes we would call for backup if we needed it, or if we knew that it was a particularly volatile situation, maybe there was a weapon involved, we would not go out alone. But in general, we would go out and assess for ourselves. And if we needed more support, we would call for that. But there are different every program is different, and it's important to know how those work. Regardless, it is important to understand, and I just want to name this, that even if you personally have, feelings about not wanting to involve the police, we do have these mandates, and it is a professional standard of practice that if a client is a danger to self, others, or gravely disabled, we do need to arrange for support and care and further assessment. It is not acceptable to just say, I don't believe in that and I'm not going to do it. Again, these are really complex topics to talk about. None of these systems are neutral. We see racism replete in all system responses and racial disproportionality in terms of, how people are harmed and who is helped and who views, for whom these services are helpful and safe, and for whom they may be very violent and fraught with their own dangers. These are important things for us to be talking about in field seminar, in your workplace, in your internships. Please bring them readily to those conversations, because this is very much a both and conversation. So I don't ever want to posit these laws as neutral. They are not neutral. And the reality is that, in practice, there are a lot of complexities and challenges that we might face. I also want to say that mobile crisis response, like with Mental Health First, for example, is only available Friday and Saturday night. Sometimes county or city, like in the city of Berkeley, their mobile crisis response to Berkeley and Albany. Most places have countywide responses. There's also a separate Alameda County mobile crisis response that responds to all other cities in the county of Alameda. City and county of San Francisco, all of the, have their own, and different ones operate differently. Some are 24/7, some are only available after hours. After hours could be defined as 5 p.m., 8 p.m. or later. Some are only available on the weekends. Some are never available on the weekends. So one of the things about being informed as a social worker is understanding what are the crisis response protocols in your space of work, how to access them, and when those spaces are available, right? And getting more information, education for yourself about how they operate. Do they go out with the police? Do they not? And how does that impact how we might talk to clients about what to expect and what might happen. Anytime a person is placed on a 5150 hold, they legally have to get a copy of the hold so that they have a legal record of why they were put on that hold and where they're going. It will say where they're going and when that hold expires. And they need to get something called a legal advisement, which explains the purpose of the hold and also a person's rights to contest it. People have rights throughout this process, the details of which are beyond the scope of this particular presentation, but I just wanted to mention that so that you are aware. So as mentioned, I'm going into more detail on Child Abuse and Neglect Reporting Act and the Elder Abuse and Dependent Adult Civil Protection Act and those limits of confidentiality in separate lectures for you to learn from more about those. I want to mention for people who are interested in eventually getting licensed, first you got to get those MSW letters, and then you register as an associate clinical social worker. And I just want to let you know that there are parts of our practice that are defined under what's called licensure law here in California, and things that both define what is a clinical social worker, what's inside and outside our scope of practice, how we advertise and list ourselves, that we may never have sex with patients, that sexual exploitation is defined, and there's an important pamphlet called Professional Therapy Never Includes Sexual Behavior that that we are required as clinical social workers, and again, this falls under the scope of practice for social workers generally. If a client discloses to you that their social work provider, whether a therapist or frankly, a social worker in a professional setting involved any type of sexual behavior, to go to the Board of Behavioral Sciences website and access this resource. I have put it on B courses for this module for you to see it. It is part of our required practice to give that information to a client so that they're informed about their rights and what they can do about that. So just want to point that out to you. So just want to acknowledge some common and concerning mistakes that we see in students in field education. We want to advise you of this now, that these are areas of concern that can cross the line of certainly crossing over in areas of ethics, and also in areas of possibly breaking the law. So we want to make sure that you're very clear about them. Going outside the boundaries of your role and your scope of social work practice, right? Your scope of practice as a social worker It is not appropriate for you, for example, to talk about the pros and cons of different psychotropic medications that someone might be taking, or it is considered outside your scope of practice, for example, to describe the legal implications of certain decisions that a client might be making, right? About medications, you'd want to refer someone to a medical provider. If they're psychotropic meds, to a psychiatrist. Ideally, they're prescribing psychiatrists if they have one. For legal questions, we need to refer to, legal experts, lawyers, or others who work in that sector. For medical questions, before you decide, oh, this doesn't really seem like, this is more mental health, I don't think this person has a traumatic brain injury, that's really outside your scope to make that determination, right? So being clear about your scope of practice, your scope of work. Talk to your field instructor about that. Talk with your supervisors about what are the lines, because as social workers, we're often helping clients to understand the context of our services, which can cross a lot of lines of medical, legal, and otherwise. School laws, special education, depending on the settings that we're in. Part of what makes us awesome, right, is that we can navigate in such a wide range of spaces and help people to make meaning of their experience in those spaces. And we can get in some sticky spots about kind of speaking up where we should not. And so when in doubt, it's good to consult with a supervisor and to be mindful about that. In terms of boundaries, while we want to destigmatize our services and we want to be accessible, to be overly informal in our relationships with clients is a common mistake. And so talking that through, and I think that what, levels of formality can be cultural, and part of culture can be age, can be, other elements of culture as well. So again, please talk about those things actively and proactively in supervision. Breaking confidentiality intentionally or unintentionally, do not ever put anything on social media about your internship. Don't put pictures, don't talk about what happened there. That really needs to stay private. It can become a slippery slope. If you take a picture of just you in your office space, sometimes we've had people post information and behind them is a whiteboard that has patient names and information on it. And you didn't even think about it because you're focused on your cute mugshot, and that is a big problem. You can get fired for that. You can have legal action taken against you. Please just leave the social media posting for your personal life, to stay on the safe side. Taking private information in your possession or on your devices. Sometimes you may be doing work from home. You may be working remotely under the pandemic. You may take something home to finish it in the evening. Want to talk more about professional self-care and making that an exception rather than a rule. That said, when you do take patient information or private information into your possession, you need to handle it responsibly. You should have a locked file box if you're transporting files. They should remain in your possession. Don't even leave them in the trunk of your car. If you go to the grocery store or something on your way home, do not leave those things outside of your possession, because you are absolutely responsible if someone else finds those things when you're taking them outside the context of your workplace. Disclosing private information to a third party when exceptional conditions are unmet. Okay, so we just talked about those 3 exceptions to confidentiality, right? Concern about danger to self, danger to others, grave disability. Those are things that could fall under 5150. So if we have those kinds of concerns, and then of course, if we have concerns about suspected or known abuse or neglect of a child, elder, or dependent adult. Okay, those are exceptional conditions. Outside of those exceptional conditions, if you're sharing private information with someone else and you don't have a release of information to do that, even if your intentions are good, even if you're doing it for the best interest of the client and it will help them maybe access housing and meet an important deadline, if you're not allowed to share it, you can't. Okay, and so finding another way, talking with the supervisor, not going rogue in those situations. Inadequately detecting or responding to clinical risk, a failure to identify risk or identifying it, but deciding that I'm just not going to make a report or consult about it. I've got it on my own. That puts you in really dangerous territory in terms of liability, but more importantly, someone could become hurt on your watch. And I know that that's not something that you want to have on your conscience. And so please do not hold these things by yourself. As a student, we talk with your field instructors about not giving you cases that are beyond your capability as a student. It's important that you not be assigned clients who have a history of violence. As an intern, you may get that as an employee, but not as an intern. And people who are actively at risk of harming themselves, sometimes we don't know that, right? Someone may present that way unbeknownst to your supervisor, but when it is known, to not put you in that situation. And if you are with someone who you are worried about being a risk to themselves or someone else, consult. Okay. Don't leave that person alone. Maybe have someone come in and sit with them. But you can certainly consult with a supervisor. It's absolutely necessary. So you can also get into tricky waters and get into trouble when you refuse to follow faculty or agency directions about these things. And so if we say on our end that this is not an appropriate case for you and you need to stop working with this client, we may talk to your field consultant about it. We've had that happen sometimes where students are being assigned cases that are not appropriate for your level of training. And we will talk to the agency about that. And if you, because you can be put in situations where you don't have the skills yet to respond effectively, and we don't want to set you up for that. We also don't want to protect you from things that are hard and saying that you can't ever learn about these things, but it is about being responsible as a collective community between UC Berkeley, the agency, and you as a student. If you're ever unsure, please always err on the side of asking. I don't say always very often, but please always do consult in matters of risk and safety for sure. You can also get into trouble with not meeting documentation standards, the quality of your documentation, the appropriateness of it, if it's gossipy or if it's fraught with personal opinion, or if you overshare details that are beyond what's necessary, that can be a problem, and you'll get feedback on that. It's not about getting in trouble about it, but it is about, these mistakes can be concerning if it's brought to your attention and you repeatedly are unable to make those changes. Timeliness of documentation. Sometimes people feel like, oh, well, it's just the paperwork, the client work is what's really important. And I totally hear that. And if you don't write it down, I want you to think about the fact that all of you as interns are part-time. Okay. And so if you have a conversation with the client about danger to self and you come up with a safety plan, you consult with the supervisor, you better make sure that all of that is in your documentation before you leave that day. That's a safety issue and it needs to be recorded and documented, because God forbid you're sick, or maybe you're not back again for a whole nother week, right? For your internship, and something else happens and other people in the clinic or the space don't have that information to support continuity of care. That can be a problem for you, right? And so even though it might just seem like, oh, it's just the paperwork has an important piece. And if you're not able to get to paperwork because of your schedule, or maybe a crisis popped up right at the end of your shift, and as I said, that often happens, please make sure you're in touch with your supervisor about how to handle the documentation and be responsible about that. Your supervisor might say, it's okay, I'll throw a quick note in there and you can write the rest when you're back next week. Or they might say, no, I need you to finish this now. And so, just want you to be aware of that. So finally, just want to talk about some, protective practices and resources. It's not all just about things you need to watch out for. Please, engage. Protective practices for yourself involves careful documentation that's reviewed by your field instructor. When you write it down, you're clearly making sure that other people know about key things that need to be recorded, and that you're continuously getting training and information about effective ways to do that. That you initiate consultation within your agency, including your field instructor, program director, other providers like risk management, or maybe an ethics committee. You can talk internally in the agency about who to go to about particular types of consultation. Sometimes maybe there's an attorney that's a part of the agency that you might talk to in particularly tricky cases together with your supervisor, for example. To initiate consultation with experts in the field of practice that are outside of your agency, including your field faculty member, child and adult protective services, or other identified persons with related expertise and experience. As I'll talk about in a later lecture, consulting with CPS about is this reportable or not does not dispel you of your mandated reporting duty, which I'll go into in that lecture. But what I want to say is that it's really important that you take care of, if you need to consult or ask them questions about how services work or things like that, that's more considered appropriate. Of course, completing this module in full, which means all the parts and the reading and the quizzes, In your Social Work 240 class, you'll have an ethics module and related reading and assignments, and your continuing education courses throughout your career, both live and online. There's advanced law and ethics classes that are widely available as a part of licensure in California. And even if you don't decide to get licensed, you can still avail yourself of those trainings. Today was just really touching on a lot of things, but touching on them a little bit. I want you to definitely go into more depth throughout your career, but we want to start you off with a clear and collective understanding of the basics. So thanks for your attention. I know this was quite lengthy, and in parts could have maybe all of it for you was really dry, but I appreciate your time and attention. And most importantly, I appreciate your commitment to ethical and legal practice within the confines of social work and learning social work. When you're not sure, consult, consult, consult. I'll work on getting you that t-shirt. Okay, take good care. Thanks a lot.